Today, a constitutional challenge to the legality of the compromise was brought before Chief Justice Kenneth Benjamin. A battery of lawyers was led by Senior Counsel Eamon Courtney on behalf of 5 P.U.P parliamentarians and the Deputy Party Leader, Anthony Moller. Because of the quickly approaching date of the referendum, the claimants asked for the claim to be tried very quickly. But Chief Justice Benjamin said that the matter, which is of national importance, could not be tried by the end of the month. Also brought before the court, however, was an application by the claimants for an interim injunction to restrain the holding of the April 10th referendum until their case can be heard by the Chief Justice. The CJ agreed to hear the injunction on an urgent basis on April 1st, with a decision to be handed down before the referendum on April 10th. Acting along with the Solicitor General Elisa Montalvo and her team for the government of Belize is Senior Counsel Lisa Showman.
The hearing was set for the urgent interim injunction that the claimants are asking for. Essentially, they were asking for 2 things: for the Prime Minister to be prevented from asking the GG to hold writs of referendum. In fact, that has already happened. That request was made back in January, and the writs were issued in February. So this is well after any such request. So what I signal to the court is that Mr. Courtney accepts that that has already happened. Okay, so what we will be arguing over in terms of injunction only will be the matter of whether the referendum can or should be conducted.
With oral hearings set for April 1st at 1 p.m., the defendants will file and serve affidavits by March 22nd, and written submissions will be given on March 25th. But it's only 9 days shy of the referendum, so if the injunction is not granted and the referendum held, what happens to the results?
I don't want to prejudge what the Honorable Chief Justice might find. We believe that there are compelling reasons for this matter to be before the court, and that's why I stress to the Chief Justice that the government itself is saying that this raises a matter of national importance. If both sides agree that it is a matter of national importance, it seems to me that the government could easily give an undertaking that they will put off the referendum until the Supreme Court has determined this matter. Let us not forget that Guatemala postponed their referendum twice. There is no magic to the 10th of April. And so I believe the rule of law must prevail, and this matter should be completed before the referendum is held.
Showman questioned why the claimants waited until now to file an injunction, since the compromise and the referendum was agreed to from 2008. She charges that the court will be looking at a case of convenience versus justice.
The issue of convenience is the issue of justice. In other words, there are Belizeans who want the referendum to be stopped. Among those people are the claimants for their reasons. There are equally Belizeans who wish the referendum to go on because the government has announced that it will be held, and they have a legitimate expectation that it will be held.
Among the 6 claimants is Deputy Party Leader Cordell Hyde. It is known that the P.U.P has taken a party position to say no to the ICJ. So is it just an attempt by the opposition to shut down the referendum arbitrarily?
Under the laws of Belize, the people of Belize have the final say, have veto over any proposed final settlement with Guatemala. In other words, we get to say yea or nay on any proposed settlement with Guatemala. What you have under the special agreement is a proposal to outsource that power to 15 foreign judges. In other words, we would be saying to 15 foreign judges, you decide this matter, you settle this matter, and we will live with it. We will have to live with it because under the terms of the special agreement, essentially what we are doing is saying it's binding. Anything from the ICJ would be binding, would be final. If we go and lose, we would be crying, weeping, gnashing of teeth, but we cannot do anything about it. And what we are saying is that that's a very far-reaching consequence of the special agreement.
And if the CJ rules against the claimants?
If the Chief Justice were to say no to the injunction, we have the option of moving on an emergency basis to the Court of Appeal, and thereafter on an emergency basis to the Caribbean Court of Justice. But all of that, Daniel, is prejudging what is going to happen. We believe that the interests of justice and the rule of law will require that the claimants have their day in court before the referendum is held.
Duane Moody for News 5.